Okay, good afternoon, everyone. Welcome to our discussion on the amendments to the National Water Act and the Water Services Act. Right now, we are about 118 people online, and we have a really great panel. I think that, you know, uh, the amendments, as always happens, was released in November 17th. And at the initial was all comments had to be submitted by the 17th of January. And there were a number of groups, including ourselves, that said, this doesn't work. Over December, we know that there's no real work happening. And thankfully, the department heard us, and many of us, and it's now the 1st of March. So if you're interested in submitting comments, you still have time until the 1st of March. We also know that around the country right now, the department is undertaking consultations and having meetings with people to talk about the amendments. If anyone does go to those, it would be good to share some of the information. I just want to add that one of our objectives of having today was we were reading the amendments and we were chatting to different people, and we thought, let's kind of formulate a bigger pool of people so that we get the different views and we can use that then to develop our submission. We will share that submission with you if you like. You can let us know. And then that's the submission that we will be sending off to the department. We're happy yeah, if you want to use it verbatim or use aspects of it, that's really great. And I think that, we were trying to say that we needed to get as many people as possible to actually comment on these amendments. The panelists that we have today, I'm going to give you just a brief intro to each of them before we get into the discussion. So we have John Dini, who is a research manager at the Water Research Commission and is responsible for leading its water governance portfolio. Part of this involves generating relevant knowledge about water law in a South African context, as well as supporting water law communities of practice, and John will explain that a little bit, and the program of water law reform advanced by the Department of Water and Sanitation. So what we wanted to do is to start off with John to give us that kind of what exactly are these amendments, what is being said, just from that kind of a viewpoint in terms of someone that deals with policy and deals with water and sanitation policy in particular. The next person we have is Anthony Kaziboni. I don't know if I've introduced myself. I'm sorry. We'll get back to that. Is Anthony Kaziboni. He is a senior researcher at the University of Johannesburg Center for Social Development in Africa. It is the leading the socio-economic and environmental justice thematic area. Among other issues, he researches the complex power dynamics behind water access in South Africa. And to Dr. Kaziboni, 30 years into democracy, the question remains, why are taps in our communities still dry? Or I should add, don't have taps. His passionate research seeks to influence policy and drive social change for sustainable water access and social development. I'm hoping that we will get Faeza Meyer online. We're having a bit of a technical issue. Faeza Meyer is a feminist water justice activist. She's been fighting long struggles, and she's based in the city of Cape Town. She has been working against the privatization of water and for access to sufficient clean water for the working class. She is a member of the African Water Commons Collective and the Western Cape Water Caucus, and is a member of the Africa Water Justice Network, and now as an organizer for WaterCAN. These are our three panelists, and just sorry for my rudeness, I am Ferrial Adam. I am the executive manager of WaterCAN. So without any further ado, we've introduced everyone. Please note that each speaker will be given 15 minutes, and thereafter we're hoping for at least 40 minutes of discussion and questions. I will now like to ask John Dini to start. I will switch my camera off. When I do put my camera on, it means that John has 2 minutes left. Over to you, John.
Thank you very much, Ferrial, and good afternoon, everyone. It's amazing to see such a strong turnout here. I am going to share my slides. And I hope someone will let me know if you can see them. Okay, I hope all is visible.
Yes, we can see it. Thanks, John.
Great. So maybe, just a bit of to build on the intro. I'm not here as a representative of the department. I'm here in my capacity with the Water Research Commission. We've been supporting the department, but the views here are very much our own. And I'm certainly not an expert on all of the amendments that are contained in the two bills. So please, there's no substitute for going to these sessions and engaging directly with the drafters and the owners of the legislation, that being the department. What I can hope to do as part of our work around stimulating a community of practice is encouraging everyone to participate in the law reform process, in making their voices heard, and maybe helping you with some of the evidence behind some of the changes that are proposed. So let's dive in. Our post-democracy suite of water law comes in the form of two acts: the Water Services Act that came into effect in 1997, and a year later, the National Water Act. And those really are the foundational statutes that define how water is managed, controlled, conserved, protected, etc., in the democratic dispensation. So they've been enforced now for a good 25, 26 years, respectively. And in that time, they've only been amended in the case of the National Water Act twice, and in the case of the Water Services Act once, which is a little bit unusual. Any law is never perfect, and especially these water laws were such a radical departure from their predecessor, the 1956 Water Act, that they were never going to get it right first time, and we certainly have learned that in the time since. But it is somewhat unusual, that we haven't been regularly updating and fixing and building in the learning as we go. And I contrast that, for example, with the National Environmental Management Act, NEMA, which also came into effect in 1998. And I think I lost count at about 9 or 10 amendments since that time. So it really just does show you perhaps how overdue this moment is. And also that, this is definitely the biggest overhaul that's happened to both of these acts since they came into force all those years ago. So definitely not a moment that we want to miss. They also are converting into law some policy positions that have been approved since, I think it was 2013 or 2014. So the law is one way of expressing certain policy positions and certain policy directions, and there are certain things that were adopted back at that time that can't be enforced until now because they haven't been converted into law. So this is a big moment to do that, and I think if you have a deep interest in what's driving some of these amendments, it's worth going back and reading this document. It's an easy read. This is available on the DWS website, and it gives you some of the rationale for the policy positions that were taken, and now they're being taken the next step to be converted into law, which then makes them actionable. So what I am going to do is I'm not going to touch on all the proposed amendments because time just doesn't allow, and I'm certainly, like I said, not an expert on all of them. but just unpacking some of the key amendments that I think will generate the most interest, the most dialogue, the most controversy, where it might be worth just keeping an eye on, as the process unfolds. I know these are things that I certainly will be watching quite closely to see where they go. So I'll run through them, but unfortunately time just won't allow for me to dwell much on them. But again, that's where the opportunity will come in at these sessions with DWS to really engage deeply on each of the proposed amendments with the department itself. I just want to move this little lobby out the way. So one of the big additions is actually a new chapter looking at the protection of what are called water source areas. We know them on the research side as strategic water source areas, and I'm sure many of you have heard of these. They've been around a while, since about 2012, 2013, and they really represent those parts of the country that generate most of our water. So those blue blobs that you see, the lightish blue blobs, those are the surface water strategic water source areas, and they, together with the groundwater the groundwater areas, represent 50% of the water that we use as a country, that we find as runoff, but they only cover 10% of the combined surface area of South Africa, Eswatini, and Lesotho. So they really are, some people call them water towers, but there's something very strategic about them. And if we are going to focus our areas around where we look after our scarce resources, it suggests that this is the place. So this is based on some work that was started by WWF, CSRR has been involved, WRC has supported, and now really there's some of the components of this work that lend themselves to being legislated are now being put forward in the form of proposals around restricting or prohibiting certain land use activities in these areas because of the potential for these activities to have such a significant impact on water resources. So I think it's a tremendous example of science into policy, and this is a journey that's still ongoing. But I think this is definitely a very positive sign, that we are, and the department is focusing in on these key water towers that we have. There's a package of measures that are really about enhancing the redress and equity components of the Act. And that's really one of the big pillars of the way the National Water Act was written, and why it was written the way it was, is to deal with some of the historical inherited inequalities from the colonial and the apartheid eras. And there's a package of measures that have got a very strong component in their rationale around supporting this, because one thing that's clear is that we haven't made as much progress as we should have. And the reasons are many. It's not easy to apportion blame to any one place, but it's clear that we have to accelerate for the purpose of social justice and equity. So there's some updates around the ability to engage in trading of water use entitlements. And part of that is linked to the recent Constitutional Court case between the department and a number of applicants on that particular issue. Some of you may have heard of it. I think it was finalized in the second half of last year. So this is the department's response to the ruling of the court in that case. Use it or lose it is one of the policy positions that was adopted back in 2013, but it hasn't been actionable until now because it hasn't been expressed in legislation. But it really boils down to the fact that many people have a right or an allocation or an entitlement to use water, but they're not using all of the water that's allocated to them. So in effect, that water is just sitting there not doing anything, while other people don't have water because perhaps it's already fully allocated. So there's this proposal already embedded in policy around either you use it or you hand it back so it can be allocated to someone who can use it. There's a prioritization of redress of past discrimination when issuing licenses. Section 27 currently lists a whole range of criteria that the department must take into account when it's processing applications for licenses or general authorizations, of which one of those is prioritizing redress of past discrimination. Now the department is proposing elevating that above the other criteria to just give it a measure of emphasis. There are many water uses that predate, or entitlements to use water that predate the 1998 Water Act. These are water rights that existed before the new act came into force. And in order not to disrupt the economic activities that those water uses depended on, a decision was made to allow those water rights to continue into the new dispensation as a transitional measure, while the new system of water use licensing was being put in place. Unfortunately, many of those existing lawful uses persist to this day, and that's part of the reason why we haven't made much progress in dealing with the inequalities in allocation. So the department is just trying to close, or let's say tighten a little bit some of the loopholes that have been used around people trying to, even now, register new existing lawful uses that date back to water they were using back in 1998. And I'm sorry, I'm not going to do justice to any of these. They're very technical, all of them, but I hope it just gives you a sense. And then lastly, looking at water user associations, which are local scale associations of water users dedicated to water resource management at a local scale. Many of them were previously irrigation boards that have been converted. And also some of the lessons learned there just around how to make these things more equitable, more inclusive, to bring in people who were previously excluded, and also to take a more catchment-based approach to their area of operation. And just in terms of evidence, this is based on some work that we did a few years back. So you'll see it's already a good 5 years out of date, but I think it still does smack you in the face. It looks at the volume of water that is currently allocated to individuals. And that is through both the mechanisms of the existing lawful uses, as well as water use licenses that have been issued since 1998. And looking at that, and that is just individuals, right? It's not corporates or anything else. But when we just look at individuals, you can see the tremendous imbalance that still exists in terms of the racialized inequalities in access to water. So that really is the problem statement for so much of what these amendments are trying to fix. I think there are some civil society types who will be very excited by the ability to hold company directors and municipal managers, and I think other managers in the public sector individually liable for transgressions of the Water Act, rather than just holding their organizations liable. So I guess what it means, in my kind of non-technical interpretation, is that you could send a company director or a CEO or a municipal manager to jail or fine them personally, rather than just fining their company or their municipality. And I know that's what some people have been calling for a long, long time. Let's switch across to the Water Services Act. This is the legislation that governs the way in which water services are provided. Even though that happens at local government level, our municipalities are responsible for that. But this is the national set of the framework legislation, the norms and standards by which they're obliged to do it. And really, again, you know, I don't think I need to tell anyone here, and I know, Ferrial, you've done a very good job of highlighting some of the challenges that we face around access to clean, safe, reliable, affordable water in our taps. We all know, we all can probably tell stories from our own personal experience about this. So really, much of this is about how do we improve the overall model through which water services are provided in our country. So there are amendments around ensuring better separation of the Water Service Authority and water service provider functions. One aims to oversee the provision of water services, and the other is the doing function. And what we found from experience is that typically the two are not always well separated within local governments. I think the big substantive, excuse me, amendments proposed in the Water Services Act is the introduction of licensing of water service providers. And I know that's already generated a lot of debate. And this is a measure that the department sees as providing better control over who is able to provide water services and ways of holding them accountable when they fail to live up to those standards. And then also based on experience around the country where the minister has tried to intervene in cases where water services are failing, the minister's realized that he does not really have very strong powers under the current act to do that. So there are now proposed amendments to enable better intervention by the minister, including stepping in and even appointing on a temporary basis new water service providers where an existing water service provider has not complied repeatedly and the Water Service Authority has failed to act against them. Please excuse me, I woke up with a frog in my throat this morning.
John, you have very little time left. Do you have many more slides?
This is my last slide.
Perfect.
Okay, so can I do it or should I leave it?
No, do it, please. It's very important.
So what I'd like to close with is just my experience from being on both the drafting side of legislation in my previous life and reviewing and commenting on legislation and what makes for a high impact contribution to that process. So what we've seen quite clearly in the National Water Resources Infrastructure Agency Act is typically people who opposed the bill that was written to enable the establishment of the agency were the ones who were writing in. And those who were in support of it generally sat back and didn't say anything because they were in support of it, they were fine. And what that created in Parliament was an impression that most people were actually opposed to the bill. Whereas that sample of submissions that they had wasn't necessarily representative of how people felt out there. It was only the voices of those who felt strongly enough against it to say so. So what I'm encouraging everyone to do is, even where you agree with proposed amendments, especially those that are likely to be controversial and where we know there are going to be very strong voices of vested interests lined up to oppose these amendments, we need to add our voices to say, yes, we support, so that it can be quite clearly seen that there are very strong voices in support as well as those strong voices opposed. I certainly would suggest that comments are submitted individually rather than collectively. And even if there might be collective discussion, is to go back to our own organizations and submit comments individually. And part of the reason for that is that they then get counted individually rather than one submission for a whole range of organizations only being counted once. And that ties to my previous point about we need to have a strong array of voices. And lastly, just to bear in mind the magnitude of the work that the drafting team and the department will have in wading through hundreds, possibly thousands of comments, to be as specific as possible, even going as far, and I know we're not all water lawyers or legal drafters, but to go as far as proposing the wording that we'd like to see in the legislation. What it does is just makes it a lot easier for the department to build those comments in, rather than these generalized comments of it's not good enough. No, please go back to the drawing board, where it's simply not possible for them to really dig deeply into that. And I think there's a risk of comments being overlooked in that way. So I will leave it there, Ferrial. Thank you very much.
Thank you so much, John, for keeping within time. Can you please email me the presentation that people are asking for it already, as well as Anthony? I think Faeza doesn't have one, but yeah, so we can send that out with the recording when we're done.
Sure.
I think you've raised some really, really important points in terms of the Water Act. I just want to highlight something that people need to also be aware of is that while on the one hand, the Water Act does talk about holding company directors and municipal managers liable, so you can actually have them held accountable, it doesn't do the same in the Water Services Act. So I think it needs to be in both, just in my view, but something to just keep in mind. I did introduce Anthony when we started, but I just want to reiterate so that people know. Anthony Kaziboni is a senior researcher at the University of Johannesburg Center for Social Development in Africa. And I want to just add one thing that to Dr. Kaziboni, 30 years into democracy, the question remains, why are taps in our communities still dry? Over to you, Anthony.
Okay, I should apologize for that. Good afternoon, everyone. Water activists, colleagues, my name is Anthony, as introduced. John, thank you so much for setting the stage. I truly appreciate the comments that you gave us. Your insights are much valuable. And as a person who's been actively involved in the water sector, I am very appreciative each time we get to engage. So before we delve into the implications of the amendments that have been proposed, let's acknowledge that water and its access, it's a resource which is a lifeline. It sustains our households, it nourishes our crops, and it fuels our industries. And let's also understand the context within which water has become contested in South Africa. There are historical issues around access to water. So my background, I'm a sociologist. I want to make the world a better place for everyone. More importantly, those that are disadvantaged and marginalized. So my discussion today will focus around mainly on what it means from us. So by my topic, from paper to my cup, navigating the meandering currents of South Africa's water and services legislation. What I want us to look at is different from what we've come across on media. I've done my own background reading of what people understand these changes to be. And largely, we've had voices from the mining sector, voices from the agricultural sector, and people from a legal background giving their insights about what these means. So in terms of context and background, where are we coming from as a country? It's always important for me to look at context and background and what it means. So South Africa, as indicated by John, has biophysical limitations around access to water. And it's a semi-arid to arid country, and we're affected by droughts and climate variability. So what it means is that our freshwater resources are very limited. In 1994, at the birth of the new country, we had 14 million people who lacked access to safe water, and more than 21 million people, half the population at that time, without access to adequate sanitation. So the lived experience of the ordinary black folk was extremely difficult, where access to water, was very limited. And this was particularly the case in rural areas and in townships. At the birth of the new country is a constitution which paved way for rights, including the right of access to water. And to ensure that there's a progressive realization of this right to access to water, we had the Water Services Act of 1997 and the National Water Act of 1998 being promulgated. So 30 years later, where are we? Why has this right remained elusive? And what are the effects of climate change? And what I argue in a number of colleagues that we're increasingly beginning to experience anthropogenic water scarcity in South Africa, which is water scarcity that is human-induced. So thinking about this and looking all of this, I will look at the National Water Amendment Bill, and I'm quite happy to say that John, you paved the way. The way in which you looked at it is the way I'll unpack it. It's actually what my presentation had been structured like. So firstly, the general prohibitions that you mentioned in order to protect strategic water resources. And this is by placing significant restrictions on development activities in mining, forestry, and agriculture. So the bans I list there, three particularly. One, open cast and underground mining with acid drainage potential likelihood, stream flow reductions near water sources without a 32-meter buffer, as well as agricultural activities without a 32-meter buffer. So what does this mean? As a researcher, I am cognizant of development and the importance of development. And particularly around point number one, it's very important to understand why open cast and underground mining have become very critical. Mining is one of the biggest threats to sustainable water supply in the country through pollution. And we have big mining companies, which are the major polluters, taking advantage, unfortunately, of government's failure to act as a regulatory system. And before the enactment of the National Water Act, there were less stringent conditions imposed on mine discharge, and much pollution occurred during this time. Coal mining profoundly negatively affects water resources, as acid mine drainage pollutes both surface and groundwater with acid salts and metals. And in this country, several areas such as the Witwatersrand goldfields in Mpumalanga and KwaZulu-Natal coal fields and the Ook Copper District have acid mine drainage. But why is this the case? Well, we have over 6,000 abandoned mines that contribute acidic water, which needs an estimated 30 billion in cleaning up costs. The Olifants River, which flows through South Africa's Mpumalanga and Limpopo provinces into Mozambique, is one example of how a acid mine can affect freshwater resources. So these mining towers, as indicated by John, need to be protected. But we also need to understand the own limitations that we have that have further adversely affected or increased pollution. And looking at mining, for example, this is one such case. The other issue of significance is the new bill that targets people in positions of authority. So as indicated, the bill tightens penalties for environmental damage. Directors and managers will face criminal charges if their company or municipality violates the environmental laws. So they could, upon conviction, a director and manager could face financial restitution, profit disgorgement, investigation, and prosecution costs. Whilst this is quite progressive, and whilst I also agree with what Ferrial indicated earlier, that we need to see some of these statutes go across legislations, there is a contradiction, however. So the section proposed on director liability does not align with the National Environmental Management Act of 1998, which is the overarching law in South Africa, upon which all other environmental laws are based. The dilemma with this is, as we look at the enforcement, again, I'll draw an example from mining of regulations. The Department of Water and Sanitation has directives around the polluter must pay principle. And this has been contested, it's been disregarded. And besides, there's some companies left mining sites or some went bankrupt. And we have illegal miners who are operating within these abandoned mine shafts. So with directors facing personal liability for non-compliance, the National Water Act has never held directors personally accountable. And under NEMA, a director can be prosecuted if they fail to take all reasonable steps to prevent an offense by the company. This reasonableness standards provides them with possible defense. However, the proposed bill entirely eliminates defense for directors. This means that it would be personally held liable, even if they acted reasonably to prevent violations, potentially imposing strict accountability than what exists in NEMA. So in this case, you see that there's the conflicting issues around legislation where this bill is introducing similar penalties to what exists in another bill. So how can that be reconciled? The third issue is water licensing and prohibitions, as well as the issues around racial quotas. So looking at this, the bill restricts water use for specific activities near water sources. So no future water licenses for open cast and underground mining with acid drainage risk for activities reducing water flow near protected areas unless a 32-meter buffer zone is there. And limited water licenses for agriculture, also requiring a 32-meter buffer zone. So the current legislation had 11 mandatory factors which needed to be taken into consideration in the allotment of water use licenses. These included existing water uses, redressing past discrimination, public interest, socioeconomic impact, as well as investments made and the project duration. So by focusing on racial quotas, I am a staunch supporter of transformation. And it's very important based on the pie chart, John, that you showed. It's very important. But we need to be cognizant of several other factors around the proposed changes. There are concerns that could raise about the discrimination and legality and potentially contradicting the principle of equality. So some of these issues, would be, deleting section 27(1)(b) removes a key legislation, a key legal foundation for considering past discrimination. The new section 27(3) might be challenged as contradicting the established all relevant factors approach stipulated across the Act. The quotas could face legal challenges based on claims of discrimination. We can also look at the implementation and effectiveness, impact on efficient water management, prioritizing racial identity over other factors, such as existing use, economic impacts, and sustainability objectives could lead to inefficient water allocation and hinder overall resource management. So there are several factors which I feel as a researcher need to be looked into. The economic and social consideration as well, impact on these existing users, as well as social tensions and divisions need to be considered. So while addressing historical injustice is crucial, the proposed racial quotas in water licensing raise significant legal, practical, and ethical concerns. Exploring alternative approaches and fostering inclusive dialogue is critical before implementing such a complex policy. Then when we go to the Water Services Amendment Bill, I'm overall in line with the distinctions that have been made. So according to the 1997 Water Services Act, all water service providers have to be approved by water service authorities as defined as any municipality, including district or rural council, responsible for ensuring access to water services. And under the bill, water service providers are still require approval, but must also obtain an operator's license. So, in South Africa, we have 169 municipalities out of 278 that are water service authorities. These constitute 6 metros, 21 district municipalities, mostly in rural areas, and 142 local municipalities. So with these issuing of licenses, what I'd be interested in issues around, the role of municipalities as in delivering the basic water services. How can it be improved? Why is it that municipalities are struggling with basic water service provision? Based on my research in the Northwest, water service provision is appalling. People don't have water in communities. And how are these compulsory licenses, this compulsory licensing going to assess that? So again, it's a discussion of what this entails, the compulsory licensing. And you also spoke about the new enforcement, which gives the minister powers. So regarding that, this is where we are. The Services Bill introduces a powerful new tool for the minister to enforce compliance within water service institutions, like water boards and providers. What this means is that there is increased accountability. This gives the minister significant power to hold WSIs for poor performance. Taking over such functions could create, unfortunately, temporary service disruption and raise concerns about local control. There are financial implications that need to be considered, and the criteria for triggering ministerial intervention and its duration remain unclear, requiring further definition. So whilst these new provisions strengthen the minister's authorities to ensure water services function effectively, they raise questions about potential disruptions and the balance between centralized control and autonomy. As a point of concluding, I hope I'm still within time, Ferrial.
You have time to conclude. Thanks, Anthony.
All right. So while access to improved water in South Africa has increased from 84% in 2002 to 87% in 2021, this progress is uneven across the provinces. When we look at the recently published Blue Drop, Nord Drop, Green Drop progress assessment reports, we can see that the Department of Water and Sanitation is in a worrying situation when it gets to water quality and management. So looking at these two proposed amendment bills that aim to improve water resource management service delivery, there are several concerns that require attention before enactment. So for me, it would be potential legal conflicts, apparent contradiction with existing legislation could invite legal challenges hindering effective implementation. This doesn't mean that we should not fight for what we believe in, but it's important that at the point of being from the drawing board, we ensure that inconsistencies are ironed out. Enforcement versus legislation. So the focus, and it's a worrying trend. I also work in migration research. It's a worrying trend that I see that we are quick to revise laws, but not ensure the fair and just implementation of the existing legislation. So where change comes from, a futility in the existing legislation, that's welcome. But if we're struggling to enforce penalties and to enforce monitoring and checks of mines, for example, then how will the promulgation of new laws, the inclusion of new clauses help us? So again, the focus should not only be on revising laws, robust enforcement of existing regulations remains crucial. Another issue of significance is evidence-based decision-making. I liked, John, I wasn't aware of the extensive work that was done to identify the regions and areas where we have our very important critical freshwater resources and the necessity for protecting them. Legislation, policy and legislation need to be grounded in an evidence-based understanding of water insecurity. Particularly for me, what I missed was water for all, water for citizens. And I think it's an important that it's an important factor that we need to start considering as we revise these laws and we amend legislation. We also need to be cognizant of, as I earlier mentioned, that water scarcity in South Africa can also be explained through anthropogenic terms, through how humans are responsible for it. Ignoring the growing impact of human activities on water access risks exacerbating such issues. And how do we address household water insecurity? So for me, this is something quite important that I would have wanted to see. So as a point of recommendation, some points of recommendation, it's harmonizing changes with existing legislation. This will circumvent, legal wrangles, legal battles, time for enforcement, and prioritize enforcement mechanism alongside legal updates, conduct a thorough impact assessment and collect data to inform policy decisions, address the issue of household water insecurity and include measures to guarantee access to water for all. Ferrial, thank you.
Thank you so much, Anthony. I think that was really great. I love how it complemented John's presentation. Can you please also send us your presentation via email, and then we will also send it to people. I think there are some really, before we get to Faeza, if I can just give you two questions to start stewing on, which is the one is that, is there any conflict between, and this is to both you and John, is there any conflict between the intent of the minister's powers over water services authorities and water services providers and the current local government legislation? And I think that's where some of these amendments are coming from. The other issue is the same thing that I've been thinking about that Julia has just added, Julia Glende, on this 32-meter buffer. For me, in terms of a water source areas, and if you know the water source areas, they vary, it's not huge areas. And 32 meters in terms of polluting with the mine or agriculture is nothing. So how they came to choose that 32 meters, and if that 32 meters is actually enough as a buffer. But I will leave those questions for now. I think that you've ended so nicely, Anthony, for us to then lead into our next speaker, who is Faeza Meyer. And as I've mentioned before, I did introduce Faeza, but she describes herself as a feminist water justice activist. Faeza has been on the ground in Cape Town fighting for access, and it's what you talk about, access for all. And so while Faeza might not give us the technical aspects of the amendments, why I think it's important for us to hear from Faeza is that she's talking about a lived experience. She's talking about the challenges she's had as an activist on the ground and how that conflicts with policy in general. We know that we have some really good aspects of our water policy, but this is an activist that's on the ground and has had significant challenges in that regard. We're running out of time, so I'm not going to go on more because I do want people to engage with the speakers. I think it's important. Faeza, are you there? And can you come online, please? Hello,
Hi, Comrade Ferrial. Revolutionary greetings to everyone. Comrade, I'm just going to switch my video off because I am doing this on my phone. I hope you can all hear me well. Yeah. You're on mute, Comrade Ferrial.
Sorry. I'll then just stop you when it's time to end, right? So you probably won't see me, but I'll come in. Okay, thanks.
Thank you. Thank you. So, comrades, greetings from wherever you are. My name is Faeza, like Comrade Ferrial just said. I think personally we need to look at the whole discussion from a holistic approach. As Comrade Ferrial said, I've been active for the past decade, struggling around the city of Cape Town and Witzenberg and surrounding areas to get access, to clean water or just access to water for basic needs for communities. And so the question I think that should be in our minds, that should stay in our minds, that we should come back to, and I think government needs to remind themselves of, is water and laws for who and for what. If we keep on reminding ourselves what these laws are for, and then I think things will go so much better. The African Water Commons Collective is the organization that I've been part of for the past decade, and we have done lots of work on the ground and worked with many working class communities, and we've seen firsthand how these laws affect people on the ground. Now, listening to the previous presentations, honestly, I probably need a workshop myself just to understand really what people are saying. But what we do know is the effects that it has on people on the ground, the struggles, the suffering. we know for a fact as the AWCC, because we've done the research. Last year, we were funded by Transforming Education for Sustainable Futures, TSF, and we did our own research in the communities, and we had 15 communities that did their own research. They mapped their own water for 7 days, measured what they use in the morning, what they use at night, you know, and what they don't have water for. And there were shocking results. There were shocking results. The one thing we can say with conviction is that the working class is not wasting water. People are using water for basic needs. People are scared. They are bullied into making arrangements to pay water that they didn't use. They are saving water that they don't have. They are doing things like that they're not supposed to, like they are not washing their hands, they are not brushing their teeth, they are not showering regularly, they're not drinking enough water. We got households of 17 people, as an example, using 76 liters of water for a day. And this is really traumatizing, because as you approach these houses, you can already smell that these people don't have enough water. And in the city of Cape Town, unfortunately, the water management devices that the city keep on testing us as if we are guinea pigs. They bring these devices with no consultation whatsoever, no conversation with communities, and install them in the weirdest times, in the middle of the night, early in the morning, 10-year-olds signing on behalf of their parents, and these meters get installed. And the meters are faulty. They break, they burst, they leak, and all kinds of things happen. People lose water, they stay without water for days, and when they get the bills, the water that ran away ends up being their problem. Now, from a working class perspective, let's talk about one law, the indigent grant. You know, this is just a simple example of how the law doesn't work for working class people. The indigent grant is meant for people who can't afford to pay, people who are unemployed, pensioners, the disabled, etc. Those are the people who are supposed to be the beneficiaries of these indigent grants. However, if you owe the city of Cape Town money, you don't qualify for the indigent grant. Whether you are a pensioner, whether you are disabled, you're never ever going to work again. Your salary, you won't get a salary, your income will stay the same, and it will be even less. They will not give you the grant. So there already is a good example of how the laws doesn't work. There's this example of the scraping of arrears. You know, they say, come, we will scrape your arrears. In meetings with the city, they say there is lots of money for arrears to be scraped. But they don't say that it's only a once-off. And if the pensioner in 2001 or 1999 had already had her arrears or his or her arrears scraped, there isn't another opportunity for that to happen. Personally, we think that if the law doesn't work for working class people, if it doesn't work for poor people, then the law must go or the law must change. That's what must happen. And how do we measure whether it works or not? We can look at the people that the services are being provided to. We can go to working class communities on the Cape Flats as an example. We've got infrastructure that is, it's broken. There is sewage running down the roads in people's in the streets, in almost every second street in Kailicha. There is sewage, broken pipes, blocked drains, and the city blames people. They say, don't put your nappies and your pads and all of these in the system, and so people are blamed. And every time we meet up with them, every time we go forward and we raise our issues, we get backlash like that. We get, you are responsible, you are to blame, and you now need to fix it. But they're not saying that they have failed to fix the infrastructure or to maintain or sustain the infrastructure for many, many years. And I heard from I can't remember the guy's name, but he's a professor, and he at UC, no, in Joburg at UJ, and he said to us that if you can look at the pipes underground, if you were able to look at the pipes underground from the city of Cape Town, you would see apartheid there, because on the affluent side of the city there is beautiful pipes, and on the poor people's side, there is infrastructure that is consistently failing. The other thing that we have a problem with the laws is when it comes out, communities are supposed to have conversation. There's supposed to be engagement. We are supposed to agree. But we are not agreeing because we don't understand the language. We are not even engaging it because we don't understand the language. The words that's being used, these big working class people don't understand. Then there's the trick words within these laws. As an example, you have the right to access to water. The word access there just means that you have the right to access, and access can mean a tap, 1,000 meters away. It can mean 20 families using one tap. It can mean so many different things. That's what access means. And so there's a lot of tricky words in these laws. Another law that affects us is the thing with the free schools. We've got free schools now. We don't pay because we are poor, but there's other ways that we are being affected. The school is now responsible to pay their own bills. They are responsible to pay their electricity bills. And when the school can't afford to do that, they put that pressure on working class people. We are now required to send water to schools with our children, even though we are already restricted. We know in the city of Cape Town that 13% of the population use 51% of the water. There's something wrong there. There must be something wrong there. How can it be that the biggest part of the population uses less water and are still being restricted? We find working class people that are so paranoid that they don't allow their children to wash their hands, that they don't allow their girl children to wash before they go to school when they have their periods. They rather stay at home for a week. This is ridiculous. The other problem that we have as working class organizations and communities is that the city of Cape Town, or government as a whole, has this one blanket approach that they just see us as poor, and so we all have the same needs, and we all have the same amount of water. That's not true. The city knows very well that the household that they call a household, there is backyarders, front yarders, people living on the side, up to 5 structures on that same property. So how can it be one household? And how can you allocate the same amount of water to that household? We are not the same. It doesn't mean that we are poor or we are unemployed, that we are all the same. We have different households, we have different needs, we have different illnesses. And the unemployment rate keeps on going up. So as the African Water Commons Collective, we have a campaign for water for life. And the reason why we call it a campaign for water for life is because that is what we want. We want water for life. We just want to live. We live in conditions where we wash our washing today and we flush it tomorrow, where pensioners are scraping ice out of a freezer so that they can take their chronic medication, where old people walk into cars because they have pink letters in their hands and they are panicking. Where is the law in all of this? Isn't the law supposed to protect people? But it's not. It's scaring people. It's killing people. It's restricting people. It is not inclusive. It is the city of Cape Town has 5 pillars. It says it's an inclusive city. It's an opportunity city. It's a safe city. All of these things, but it's none of the above. We are not safe in our city. It's not inclusive because we are not included when decisions are made. This is not a caring city where a pensioner has to scrape ice out of the freezer and a young girl has to stay home because she cannot go to school smelling of blood. This is ridiculous. So we will continue to fight and we will continue to push and we will learn these laws and we will learn the language of the government and we will argue them and push back because we have to push back as a collective. I hear the first speaker said it's better to respond, individually than as a collective. And I know I was late in the conversation and I got a bit of a shock there because I was like, no, the collective is always more important than the individual. But then I heard what you were saying about we need to flood them with our responses, and I totally agree with that. The African Water Commons Collective, together with the WaterCANs, we're not going to just continue to measure, to do our own research. We are also now going to test the quality of our water, and we're going to learn how to hold government accountable, because we cannot trust them. They do not come to the party when we call them. They do not invite us to the party when they're busy discussing, and so therefore we cannot trust them. We have to continue the campaign for Water for Life. Thank you, Comrade Ferrial.
Thank you so much, Faeza. And I think it's important to have a perspective of someone on the ground and how this impacts to someone at a grassroots level. So thank you very much for that. I will open the floor now if there are any questions. I do have some that have come through. I really want to thank our panelists. I think that it's a range of input so far. I'm just going to read some of these questions and then I will ask the panelists to respond. So the one I have is from Erna. What are the implications for community level access for poor rural communities? Are there any options for public-private collaboration? And then Julia had the one on the 32-meter buffer, which is also for me baffling, a baffling buffer. And Stephen says the same thing. It's the 32-meter buffer is a mysterious case. He doesn't know where it came from exactly, but does know that there are far more up-to-date ways of deriving appropriate buffer zones. And Roger, I asked that question already. Are there any other questions, or would anyone like to ask their question? The floor is now open. Mariette, please go ahead. You can unmute yourself and go ahead.
Thank you very much, Ferrial, and thank you very much for the insightful and meaningful presentations. I just want to refer to the National Water Act and the revision of Chapter 3A, that is the protection of water source areas, and that is Section 20B, 1 and 2. I just want to ask some clarity. I do understand the statement that there should be a prohibition on any open cast and underground mining which may lead to acid rock drainage or acid mine drainage, particularly in water source areas which are threatened or vulnerable to mining. This, of course, is aligned to the actions that have been proposed in 2020 in the master plan. It's only now being considered. But in subsection 2, it mentions that the minister shall publish a notice prescribing the review of water use licenses granted on mining activities contemplated in subsection 1 prior to the commencement of this chapter. From that, I understand or infer that there will be a retrospective application. I just need perhaps some clarity on that, if my inference is correct. And this, of course, is also, if I may interpose, just mentioning that cost orders are already being requested and granted, that is requested by the Department of Water and Sanitation against NGOs who are endeavouring through legislation to ensure the protection of these water source areas. And here I refer in Kasa to the Ngangala, Drakensberg water water source area. That is my one question. And then just on Section 19 of the National Water Act, it does not hold directors personally liable. So that is a comment on what had been presented, because in Section 19, only an owner of land, a person in control of land, or a person who occupies or uses the land which causes pollution can be held accountable or responsible and liable. So I think that is an improvement on our current Section 19 of the National Water Act. Thank you very much. These are my comments.
Thank you so much, Mariette. Can we take a few more questions? Anyone? So I have a question that's come up. I just need to have a look at it. Quick one for you, Anthony. With all the water acts, do you think that there is a political will from the ruling class to provide people, especially those in rural provinces, with water? That is from Ezekiel, from Kakana, from the Helen Suzman Foundation. Can I ask, perhaps if each of you could respond to some of the questions that have come out? Yusuf, I see that you've been responding a lot from Cape Town, and maybe you want to come up and say something? Okay, Anthony, I see you've put your camera on. You can go first.
Thanks, Ferrial, and many thanks to people who've asked questions. I'll discuss just three key things that I feel I'm capable to respond to. I'll start with the last one regarding the ruling class and whether there is political will to ensure that there is that there is access to water for people in rural communities. And unfortunately, it's the contradiction with legislation. When we look at, apartheid spatial planning, which was spoken about by Faeza, where you see that communities and townships and communities, as well as in rural areas, have little to no access to water infrastructure. Whilst there have been some milestones, in the post-apartheid landscape, when we look at where we are now, 30 years later into democracy, we see that a lot of people are still struggling with basic access to water. And I'd be wary of using the term ruling class because it seems to suggest that there is an elite, but the reasons why water service delivery has been a challenge is actually multi-layered. So I think that's the one. I liked the direction that Faeza took this conversation. And at the beginning of my presentation, I spoke about how if you check about comments on the amendments, a lot of them have come from people in the farming sector protecting their businesses, people in the mining sector protecting their businesses. And it's not that which I think I might have come across as though I'm supporting the mining industries, I'm supporting the farming businesses. I'm not. I'm supporting the human right to water. So Faeza's presentation speaks directly to the issues that I'm raising, that we are here. Why is there no water in my cup? When this was an issue that we faced, during apartheid, and this is democracy. And in my own research, I look into what people think and feel about what citizenship means in a post-apartheid landscape when they're struggling with basic water access. So to the people who put together such legislation, it's important that we start having open and frank conversations with communities around access to water, and ensure that we tailor and develop policies that speak to access to water for everyone. We can then see how we can transform society across. But the conversation around transformation, when Faeza, myself, Ferrial, and many other people know of people who don't have water, it seems a bit far-fetched. What we need is water, and we need water right now. In terms of liability I think it was Mariette, I'm not sure if I heard your question. So your question correctly, the angle at which I'm coming from is an angle in which we need to harmonize legislation. The NEMA already deals with penalties and holding directors liable and people in positions of authority and influence liable. We like implementing legislation. And 5 years after the implementation of a new clause, we spend 4.5 years going to court and out because we are unsure about what it means. So the appeal I have, particularly on the proposed amendments, is to ensure that they're harmonized with current legislation, that they're in line with current legislation. I'm not a lawyer by training, I'm a sociologist. I may not even be able to understand the clauses as you explained them to me. But as a researcher who has experience in researching these issues and finding out what the key contestations are, what people on the ground feel, it's important for us to move systematically and to harmonize new legislation with current legislation to avoid the points of conflict. If there are changes, the changes should go across. Thank you.
Thank you, Anthony. John, I think there were quite some specific questions to the policy that maybe you can assist in terms of the governance aspects. I think Mariette's question was very specific. Can you assist with that answer? Thank you, Anthony.
Sure. Thanks, Ferrial, and thanks for all the questions. Yeah, well, I think Ferrial, sorry, Mariette, I think your question is better directed to the department. I mean, that's precisely the kind of question that I think they're in a better position to deal with. What the Water Act does enable currently is it makes provision for water use licenses to be reviewed under certain conditions. And I think the department is invoking that existing clause to enable the review of licenses that might overlap with strategic water source areas. But I think it's a useful question to pose to the department itself, because that's just me looking at it from 1 foot in and 1 foot out. There were a few other questions. Rural water provision. That's a tough one, because we come from a time, we need to cast our minds back to the 90s. And South Africa was a very different place than it is now. And there was much more of a sense of possibility and optimism than there is now. And there was much more of a state-centered approach to delivery of basic services, the developmental state. So there are senior people in the department who are quite open now about how options for community-based, community-led, community-driven forms of water supply were deliberately diluted in the Water Services Act, because the emphasis was on building local government and making local government the primary vehicle through which everyone would get access to water. We all know that it hasn't worked out as we planned. Personally, I don't think these amendments are really tackling that problem, is that we need to look beyond the current models. So there's been no changes made, for example, to the chapter on water services committees, which is like the closest thing you get to bringing communities into the picture. Especially, there are communities out there who've taken matters into their own hands and are self-supplying water. So I think there's a diversity of modalities that we now start to consider. And someone said, what about the role of the private sector? Sure, I think that's also, we're in a very different space in that conversation now than we were back in the 90s when the Act was written. So, it's possibly something worth interrogating a bit further, the extent to which more community-owned, community-driven, community-based approaches to local scale water provision are being enabled through these amendments, or if something more is actually needed. The minister versus local government, again, that ultimately boils down, it's a legal issue. The Constitution is the ultimate kind of rules of the game, right? And what the Constitution does is it assigns the ultimate executive function for the provision of water services to local government. But they have to do so within the framework prescribed by national legislation. So the minister has a role there in terms of oversight, policy making, norms and standards, ensuring compliance. And I think that's what's happening now, is the minister's flexing his muscles around his ability to regulate water service providers. It may well boil down to some kind of constitutional analysis in a court of law around where that line is and whether the minister has crossed it. None of us in this room are constitutional lawyers that I have recognized in the names. And I think ultimately, what's becoming clearer and clearer is that problems of water service provision are actually linked to problems with the model of local government inherently. So you don't find a strong local government and poor water service provision. You find poor local government and poor water service provision go hand in hand. The minister, however, and we know we need to relook at some of the assumptions that were made about the local government model, especially the way it funds itself, the way in which local government was going to be funded. And our minister cannot reform the system of local government. It's way beyond him, and I don't know if anyone has the courage to tackle that right now. What he can do is attempt to tackle some of the symptoms, and that's exactly, I think, what he's doing through these measures that he proposed. In so doing, he won't be able to fix the system of local government, which is the ultimate, I believe, cause of many of the problems, but he's able to mitigate some of the symptoms of those failures. CMAs, apparently, I spoke to someone again at the department today who assured me that we should have all our CMAs up and running later this year. So don't hold your breath, but...
Is it 7, 5, or 3? It changes.
6. We have 2 up and running, and we have a boards appointed for the other 4. The National Water Resource Strategy 3, which came out last year, rationalized the number to 6, and I think it makes a lot of sense in terms of introducing new institutions into the already strained fabric. So I think we must think about life with CMAs in it rather than, and I know, it's fine to be quite cynical given that it's taken us 26 years to get to a state we've only got 2. Can I touch on 2 last things, Ferrial? I don't want to hog all the time. Or should I hold?
I'm going to ask one more question and then ask each of the panelists to wrap up because we are running out of time. I mean, I think that this is just a beginning, and for us to wet our minds and get people to comment and get people to submit their comments to the process. And that's why we're having this webinar. We'll share all the information. I just want to finish off, I think, and ask in terms of for everyone, for all the panelists, and this is the last one. Maybe with this, you can each sign out, say your last comments. But one of the things that we've seen in terms of the comments that are coming through, and I think it's Alana, I'm sorry, I missed the surname. And she asks a very good question because it's also something that I've been thinking of, is that are you a player and a referee? And does our government or national department have the potential or the ability to enforce all that this allows to do? What is being put in place to ensure that these amendments actually are enforceable? So that's exactly what her question is. Can DWs actually handle this? And I agree with her. And I think the CMA question has been targeted. So I think on that, I'm going to start with Faeza because she hasn't, just to come in and just some final comments. Very simply, in 1 or 2 minutes, please say your last bits, each of the panelists, before we close off. Thanks, Faeza.
Thank you, Ferrial. Yeah, and thank you to the previous panelists. I think I want to answer your question, Ferrial, that I don't think there's a political will for DWS, to move forward and even implement what they are saying. I mean, we have experience of engagement. We have experience over the years of trying to engage with them, and we constantly come up with the same thing. They ask us, who are you, and how can we help, and what are you doing, and where are you working, as if they don't share information with each other, as if they don't care about grassroots organization. Every time there's new people, there's new questions. And in terms of the engagement, there was a response in the comments about that there is engagement everywhere, at every municipal level there's engagement. Yes, but how is this engagement? We have engagements in gang-ridden areas at night. Municipal meetings, they don't advertise it properly. When you get there, the ward councillor tells you a presentation and he says it will only take 5 or 10 hands, and that's it. That's not engagement. Our government needs to figure out what engagement is, or they need to find the political will, or the will, just the will to want to do this, because I don't think they have the will to respond.
Sorry, Faeza, are you done? I didn't mean to cut you off.
Okay, now and then I just want to say, you know, the African Water Commons Collective is ordinary people, and we're working on alternative strategies. You know, something simple. People came up with, why are we using clean water to flush our toilets? You know, why can't we supplement that with other kinds of water? So the working class is aware of what they want. We are not stupid. We know exactly what we want. We know what we need, and we can sit by the table and speak to our own needs. And that's all that the government needs to take into consideration. We are there and we are aware and we know what we want. Thank you.
Very powerful. Thank you, Faeza. That is very powerful. I think that you've raised a few things on engagement. You've raised issues on being present and knowing what you want. And I think that is really, really important. Anthony, can you sum up and answer the last few points that were raised? Or add anything that you want to?
Yeah, from my side, it's political will, and I argue for a moral and ethical rejuvenation, particularly within local municipalities, because of their proximity to communities and their role in water service delivery. South Africa is known to have the most liberal constitution in the world, and one of the most liberal constitutions in the world, and there is robust legislation that, if properly implemented, would ensure the realization of the right of access to water, the right to water. However, in local governments, the Auditor General's report, if you look at them, the picture painted is very disheartening. You will realize that financial mismanagement and corruption, what was the allegations, they're off the charts. So a lot of taxpayers' money is misused, and communities don't benefit, communities that are already struggling with the triple challenge. With the department, there are also systemic issues there. I am aware that there's a skills shortage, and having looked at the challenges that both these two separate entities, the Department of Water and Sanitation and local municipalities that have a responsibility of providing water, we need to, before we imagine new legislation, I think that's my worry. Before we imagine new legislation, we need to ensure that current legislation is implemented to the T. From then, we need to ensure that there's a meaningful discussion, not only with people in business, but communities, grassroots communities, people who are struggling with basic access to water, what their issues are, and ensure that we have policy recommendations and we have legislations that ensure that ensure that people get to live the life that's promised in the Constitution. I'll leave it there. Thank you.
Thank you so much, Anthony. Yeah, I think that was really important. I like the idea of, we need to deal with present legislation, but I think also if you're trying to strengthen the system. Sorry, Yolanda, someone's WhatsApping me the questions because I can't see the screen. I'm chatting to people, so that's why I didn't get your surname. Apologies for that. It's Dr. Alana Robello, if anyone wants to know who asked the question previously. John, over to you.
Thank you, Ferrial. And let me use Anthony's remarks as a starting point to close mine. The question that we've grappled with over and over again around water law is, to what extent do we revise the law to fix things that might be inherently flawed in the legislation? And to what extent do we revise the law to deal with problems in how the law has been implemented? And it's so important to know the difference between those two. We don't want to rewrite the law in an attempt to fix the way the current law was being implemented if the law was fine, okay? Having said that, there are a lot of National Water Act loyalists who were part of Kader Asmal's process who now are saying that a law that cannot be implemented is actually bad law, and we really need to take a step back. So that's where the issue around capacity and enforceability becomes so important. I believe that elements of both are actually present in these amendments. I think there are aspects of the law, as I mentioned in my first slide, that are sorely in need. They're outdated, we've learned, there are things that need to change, there are court decisions that need to pull through to law. Those are changes that need to be made regardless. But there are still challenges around implementation of the existing law that we haven't resolved. So I think these are very useful things to keep in mind around, to what extent are we deflecting from existing implementation challenges by just trying to write something new, and to what extent do we need genuinely to bring about some changes. And I think there are always going to be elements of both. So I think it's an incredibly positive process. I think even if the capacity is not there now, it's something that we can develop incrementally. It's better to have it in the law and not be using it immediately than need it and not have it in the law. Who knows when the next amendment process will be. So even if we get things into the law now and we start, as you can see on the WSP licensing, it's an incremental process. So we need to take a long view. I would love to engage Alana on the water trading issue, but it's a long conversation. I would refer Alana to the water policy positions that are available on the DWS website, because they sketch the problem statement, and it's really around keeping water in the hands of the haves and circulating it among them rather than sharing the water with those who don't have. And a lot of people have got very, very rich in the process from a resource that is actually owned by the people of South Africa. But that's another seminar all of its own. I'll leave it there. Thanks.
Thank you so much. I think that I've been trying to follow some of the comments, and I haven't been able to see all of it. But firstly, let me thank the panelists. I think that the combined input has been very fruitful. We will make this recording available. We will, Anthony, so many people have asked for your presentation, and John, please, if you can, add it onto the chat so people can get it now. Otherwise, please email it and we will send it out to everybody. The other thing is that on this webinar, we had government people, we had different sector specific, whether you're in agriculture or mining. We've had activists, researchers, and I think the diverse kind of crowd shows the importance that water has, and that the importance it is to watch the amendments, whether we like them or not. It is important for us to all get our voices into it. There was a comment that said this was not enough time to really unpack the amendments. Colleagues, the purpose of today was to start the conversations. You have to go back and unpack the amendments, and please submit comments, good or bad. As John has said, on the 1st of March, we need to make sure that we are heard. I know that there's consultations around the country. Some people can't get to those, but please, if you can, try to ensure that people do comment, especially if you have access to this webinar. Hopefully you'll get some ideas on some of the things you need to comment on. But thank you for the questions. I think that they were really good. There's, of course, a lot that's still there in terms of, if you change the law, do you have the ability to enforce? What does access mean for ordinary people and community people? Mariette raised a very specific clause, and I hope she's going to find a way to respond to that in the comments into the submissions. But thank you everyone for your questions, participation, and focusing. We will send you the recording and we will send you the presentations, and really, really thank you to the panelists. I think it was very important to hear the different perspectives, and they really welded well together. Thank you, everyone. Have a great day. And for Valentine's Day, we'll be going to 5 mayors to give them some dirty water and dead flowers as an indication of our lack of love for them. So we're breaking up with them on Valentine's Day. See you all soon. Bye.